Hello and welcome to the Rogers Brief for December 17th, 2022. I'm Adam Rogers. Thank you for watching and thank you for listening. For those people that are interested in the content around the Mass Casualty Commission, there's two things you can do. One is recorded a podcast Sunday night, which was a live YouTube feed with Jordan Bonaparte and Paul Palango. That's now available as a podcast, and if you subscribe to the Nighttime podcast on YouTube, you can see the video as well. And then, so that was a year-end episode, and we went back through some of the, what we've learned over the past year, some reflections, and then also some discussions about the final moments at the big stop. So I think people will find that interesting. And the other thing is my ebook, my report on the Mass Casualty Commission and the events that precipitated the Mass Casualty Commission, called Deficits of Trust. I've been preparing something of an audiobook so I'm doing YouTube videos, which can then, you can watch the YouTube video of me reading the Deficits of Trust report, and you can also download that as a podcast as well if you're interested in listening to that as you go for a drive or go for a walk or work around the house, however you listen to podcasts. So just mention those two things. I'm going to focus this week on three stories. One is, they're all out of Nova Scotia. One is a case where the Court of Appeal had some very harsh things to say about the RCMP's treatment of an accused who they tried to arrest at his house. Well, they did arrest at his home. The second one is the divorce appeal of John Risley, the wealthiest person in Nova Scotia. And then the third is some machinations, I guess you'd say. The Liberal government looking to interfere with the Independent Electoral Boundaries Commission, which submitted a report on redistributing the federal riding boundaries in Nova Scotia. And so now the Liberal government is signaling that they're going to challenge that. And so I'm going to talk about the appropriateness or lack thereof of that. But before we get to that, just a couple of things. One is an update from a story that I've covered the last couple of weeks, which is this Alberta Sovereignty Act, the Alberta legislation where the provincial government there has enacted legislation where they say, well, if the federal government is interfering in provincial jurisdiction, we're going to do something about it. We're going to push back. And so there were amendments made to that and so on, but now the legislation's in place. One of the first things that they've done now, the Justice Minister just a couple of days ago issued a press release and wrote a letter to the Federal Justice Minister saying that firearms offenses, which is federal legislation, is now going to be prosecuted by provincial Crown prosecutors. Now, I was a little puzzled by that announcement. The main reason I was puzzled by that announcement is that this is the way it already works. So when you go to court, provincial court, you have federal prosecutors and you have provincial prosecutors. Well, federal prosecutors deal with drug offenses and they deal with fisheries offenses and employment insurance offenses, but usually the first two, drug offenses and fisheries. Even though, like, the Criminal Code is federal legislation, the Firearms Act is federal legislation, but those are already done and handled by the provincial Crown prosecutors. So I'm not sure exactly what Alberta is trying to say here. It seems more likely there's another little twist to that, which is that the Justice Minister wrote to the provincial Crown prosecutors to say, use your discretion if you think the new firearms regulations should be prosecuted. If that's in the public interest, then go ahead, and if you don't think so, then don't. So I think what it is a subtle way, or maybe not so subtle way, of instructing the provincial Crown prosecutors not to prosecute these new federal firearms regulations. So we'll see how that goes in Alberta. It may spread across the country into other provinces. Okay. Second thing is we're into holiday season and holiday party season, and so there's a couple of things. One is I noticed an article, this is out of France, but it was commented on by some Canadians, which is somebody didn't want to go to a party, didn't want to go to a work party, and they got fired. This was in France, and so they took their employer to court and were awarded a judgment, a small amount, $4,300, but the French court there described the right to be boring. Interesting way of putting it. Probably wouldn't be the way a Canadian court would put it, but didn't want to go out to an after-hours party. It wasn't during work hours, and there was going to be alcohol served, and didn't want to do that, and so didn't go and was fired. So I guess the Canadian equivalencies to that would be if it's something that's happening in the office during the day, you're probably expected to go. You don't have to consume alcohol, of course, if you don't want to. If it's something after work, after hours, you are not compelled to go. Second thing about Christmas parties is host liability, and this comes up every year. And so basically, if you're hosting a party and things go a little crazy and people start breaking things and people leave and they're have consumed alcohol and they go get in a car accident or cause damage somewhere else, you as the host can be liable or found liable for that behavior. So it's host liability. So some of the things that you should do as a host of a Christmas party, should have some non-alcoholic drink options. Don't spike the punch. You should have some plan or some thought to alternate drives home for people that have driven to your place. You should keep an eye out for very obvious and clear bad behavior, and just make sure if it's if it's winter in your area that you shovel the snow, salt the walk, make sure nobody slips as they come in and out of the home. So just some things to think of for host liability for Christmas parties. Okay. First case I want to talk about is R versus Mitchell, King versus Mitchell. This is a 2002 Nova Scotia Court of Appeal decision, just released last week. Made some news as well, because what it did was it called out some pretty egregious police behavior. This was a case out of Windsor. It was called out by the trial judge, Judge Greg Lenehan, who's a judge with a very good reputation, and then that was supported by the Court of Appeal. Now, Judge Lenehan had acquitted the individual, actually instituted a stay of proceedings. And a stay of proceedings means that the case is basically on hold. Sometimes the Crown will issue a stay. It lasts for a year, and they may choose during that year to bring the case back or not. The person's not free and clear while the stay is on. The time frame has to pass. But when a court does it, it's a very serious matter. And so in this case, the trial judge, Judge Lenehan, had done so, and the situation was this. The individual had, Mitchell, had 32 charges, domestic violence charges. Of course, that's a lot of charges, but I wouldn't read too much into the just sheer number of charges. I don't know the situation behind those, and that's not included in the court decision, those description of the 32 charges or the allegations. But often those will arise out of, the police often overcharge somebody. There'll be one incident and you look at the information and there'll be 8 charges all sort of related or overlapping. And then by the time you get to a guilty plea or a finding of guilt by a judge or a plea deal, you might be down to 2 or 3 charges. So just keep that in mind. So Mitchell was on a curfew and he had to present himself at the door if the police showed up. And so this was the complainant from a relationship of a few months earlier had made a complaint to the police just a few hours prior to this all happening. So the police went to his home, of course knowing he'd be there, but they didn't have an arrest warrant. They also didn't have what's called a Feeney warrant. Now, a Feeney warrant is named after a case, Feeney, where this was determined by the Supreme Court of Canada that this was necessary, which is permission to enter somebody's home. Now, you can have an arrest warrant, and if you're out on the street or out in public, you can be arrested by the police if you're subject to a warrant. If you're in your home, they have to get judicial authorization to enter your house to arrest you, unless there's some exceptions. So the exceptions are if they know that there's something going on inside the home, some imminent violence that they need to prevent, or if they can tell that you're destroying evidence or are about to destroy evidence, and they need to enter the home to prevent that from happening. Neither of those applied here. But what happened was the officers, there was 3 of them, and Corporal Bezanson Corporal Bezanson and Constables LaHaye and Constable Graham. Sorry about those names. Okay, so but Corporal Bezanson had told them, make sure he comes outside so we can arrest him. Well, he didn't. Mitchell knew, I guess, more about the law than the police did in this case, because he stayed in his home. The police said, we're here to arrest you. Would you step outside to be arrested? And he said, no. And he closed the door and locked the door. Well, Corporal Bezanson took 8 steps back, and there was video camera footage of this, or else we wouldn't know any of this, I'm sure. Took 8 steps back, rushed the door, kicked it open, and went in. And he was going to be claiming, and he did try to claim, but would have been probably more persuasive without the video evidence, that he was in hot pursuit of Mr. Mitchell. So if you're in hot pursuit of somebody, there's another exception. You can follow them through the threshold. It's not, you can't just cross the door threshold and, escape the police if, they're chasing you. So, but that's not what happened here. The corporal busted down the door, went inside, and pulled out Mr. Mitchell and arrested him. Okay, so that is a clear violation of his Section 8 Charter rights to be free of unreasonable search and seizure. And normally the remedy there would be to say any evidence gathered as a result of that unreasonable search would be thrown out. But the domestic violence charges, the 32 charges, whatever was the foundation of the police going there in the first place, those charges could still continue. Mr. Mitchell took it a step further. His lawyer, Jack McDonald, took it a step further, which was to say this was a violation of his Section 7 Charter rights to be free from any harm to his life, liberty, and security of the person. The remedy for that is a stay of proceedings, because it's called an abuse of process, which is where the police or the Crown abuse the process of the court or of the law to such an extent that society would be outraged, and therefore the original charges get withdrawn, or there's a stay issued, as was the case here. So it's a dramatic remedy, of course, but the idea behind it is we can't allow police to do these kinds of things, and there has to be a serious remedy in order to get them to not do those things. There was a great, a line by Judge Lenihan, who said the officers should have hauled the corporal out of the house, not Mitchell. So quite strong language there. And actually that was a interesting case, very, pretty egregious breach by Corporal Bezanson. We'll see if there's any disciplinary action taken against him as a result of that. It's, not great to have a judge say such things about you, and there's video evidence to back it up, so it should be a strong case there. This was there was a little procedural situation or element to this, which is kind of interesting as well, which was the Judge Lenihan issued an oral decision, which is a little unusual for a complicated matter, but what was going on, this was pre-trial, and the application was made for the charter remedy, and so he told them basically, all right, here's my decision, I'm going to give you written reasons later. The reason he gave the oral decision was to prevent people from having to then prepare for a trial, which wasn't going to happen. So he gave the oral decision, and then, a month later gave his written decision. Well, in the meantime, the Crown appealed the oral decision, and then they were saying at the Court of Appeal, the court couldn't consider the written decision because the written decision was made after the judge knew that there was an appeal coming, and the written reasons were tailored to sort of counter the appeal that was forthcoming. Well, Court of Appeal didn't buy that. It was clear right away, the judge said so when he gave the oral decision, that he was going to do a written decision. And there was nothing dramatically different about the written decision as compared to the oral decision, so the Court of Appeal didn't allow that either. So pretty unsuccessful appeal by the Crown there, and there should be some further consequences, I think, for the RCMP officers involved. Okay, next case. John Risley. and his former spouse Judith McDonald, married for 40-some years, divorced in 2018. There was a consent corollary relief order. So divorce by consent, had a separation agreement that everybody agreed to. $150 million transferred from Mr. Risley to Ms. McDonald. Of that, most of it was shares in Clearwater and GFL and another company, but $10 million of it was supposed to be in cash. Well, the issue was John Risley thought that it had been paid, or was trying to claim that it had been paid, and Miss McDonald was saying that it wasn't. Now, John Risley said that it was paid to her and also to their children on her behalf, so that anything he gave the children, and he'd given them some millions of dollars, half of that was her share of a gift or a conveyance to the children. Well, she says that those payments that were made, and there was I think $2 million something in cash that was paid to her, that these were advances on dividends or dividends from those companies. Now, there were two issues that came up. One is, well, who was right about that? And then the second one, John Risley had sought to bring in fresh evidence at the Court of Appeal hearing, which you normally don't do, to say, get her tax returns to show that no dividends had been declared. Well, there's a couple of problems with that. One is there's a test for fresh evidence called the Palmer test, and the first and main issue is, could this evidence have been brought in at the original hearing? And the clear answer to that was yes. In this case, it wasn't Mr. Risley personally, but his companies who prepared his wife's or his ex-wife's tax returns. So he was aware of those details and could have brought them in at the original hearing, didn't do so. So really for that reason it was rejected. And then also the judge, there was evidence, there was emails back and forth from Mr. Risley to Miss McDonald's brother, who was sort of her agent in these discussions, and all kinds of evidence in the other direction to say that those were dividends, those were other things, those weren't. Nobody had considered that part of the $10 million. So the judge said this was a baldly stated position, and that his baldly stated position was different than what he had stated in his emails. So just saying something doesn't make it evidence. So from the Court of Appeals perspective, there was no genuine issue here, and that therefore they dismissed the application and affirmed the decision of the lower court judge. Some interesting parts of this. Okay, so so Mr. Risley now needs to pay the $10 million in cash. The appeal panel were Justices Beveridge, Farrar, and Beaton. The lawyers on the case, this was kind of interesting, I thought, were Michelle Awad from McGuinness Cooper and William Ryan from Stewart McKelvey, two real litigation heavyweights, two of the top litigators in the province, but not divorce lawyers. So I thought that was a little curious. The appeal, the original decision was made by Justice Greg Warner from the Supreme Court. So anyway, interesting decision. Shows sometimes, I guess, that even the very wealthy have their own problems. So third thing I wanted to talk about, and I don't need to talk about this too long, I guess, but it was in the news this week. It's so the Electoral Boundaries Commission does a report every 10 years on the districts, the federal election districts, and they recommend whether those should change based on movements of population and these other things, communities of interest. There's other things that are factors. Well, that did take place now several months ago, and the report just came out now, I think a couple of weeks ago, saying, yes, there's going to be some changes to the ridings in Nova Scotia, including a change to the two Cape Breton ridings. The current riding of Cape Breton-Canso includes Glace Bay, which is 18 to 20,000 people, part of CBRM. That is now going to become part of Sydney Glace Bay riding, so more of an urban riding, and then the rest of the island, so Victoria County, which was part of Sydney Victoria, and Eskasoni, which is near Sydney, a Mi'kmaq community of several thousand people, not too far from Sydney. Those are now going to be part of the what would be called Cape Breton, Canso, Antigonish, or maybe Cape Breton, Antigonish. So including the rest of Cape Breton rural areas, as well as eastern Guysborough County and Antigonish. Okay, well, the current MP, my old law school classmate Jaime Batiste, has come out in the news, as well as Chief Leroy Denny from Eskasoni, to complain about the change of Eskasoni being moved from Sydney Victoria to Cape Breton, Canso, Cape Breton, Antigonish now. So I was looking at that, and some of the comments in the article I thought were pretty inflammatory. There was a comparison to residential schools and centralizing Mi'kmaq influence and redirecting Eskasoni's channel of communication with the Crown. And anyway, it was quite inflammatory rhetoric there, I thought. So I was looking at the numbers. I was like, well, is this the case or not? Right now, Cape Breton Canso has, if you go by the census information, an Indigenous, a population of 71,000 plus, an Indigenous population just over 5,000 it's a 7.1% of the population. Okay, and Sydney Victoria currently has 72,000 some, with about just under 7,500 Indigenous population for 10.3%. Well, if you take Eskasoni and flip it from one riding to the other, then the percentages really just flip as well. So the current Cape Breton Canso riding, if you add Eskasoni, would have 10.7% Indigenous content, and Sydney Victoria would have 6.7%. So really, I mean, there's decimal places of a difference. Eskasoni is going to have the same relative influence, and the Mi'kmaq Nation is going to have the same relative influence if you consider those two ridings. So not sure what the exact complaint is. It seems to me that this is really just an attempt to override the independent Electoral Boundaries Commission for political purposes. Now, this is just a local effort so far, but this is the Liberal government, and we'll see if the Prime Minister's office or the cabinet supports these kind of comments. You see this a lot in the United States, this gerrymandering is what it's called. It's an old style word, but that's basically what it is arranging congressional districts in the States or electoral districts in Canada to suit a political party and the political party that's in power. So it's not really quite improper, I think, for the government to be making submissions. Actually, I made a submission at the Antigonish consultation, and I noticed Minister Fraser was there. I was a little surprised, actually, that the government would show up. I mean, this is supposed to be, like I said, an independent operation. Now, Jaime Batiste and the Liberals are threatening to use the Electoral Boundaries Readjustment Act, which is something that Parliament can do. They need the support of 10 other members of Parliament to support a motion, and then an appeal gets made back to the Electoral Boundaries Commission. It was anyway a reputable commission who consulted widely and made changes that make a lot of sense to a lot of people. The criticisms that were in this article in Saltwire a couple of days ago from MP Batiste and Chief Denny really didn't make any sense. And it really just seemed to be, showing concern by the Liberals that they don't think they can win that seat. So I'll be watching for that. That's something that we'll probably see in the new year manifest itself in Parliament, and we'll see if the government at large supports this kind of interference. It seems to me improper political interference, but we'll see what others think. All right, those were the stories from Nova Scotia that I thought were interesting this week. A little bit of Alberta and French content as well. Everybody be safe at your Christmas parties, holiday parties, and we'll Be back next week with more from the Rogers Brief. Keep an eye out as well. I'll be looking to record another episode or two from Deficits of Trust this week, so you can watch for that as well. So until then, thank you everybody for watching. Thank you for listening, and we'll see you next time.